Court has struck down the National Judicial Appointment Commission law, which seeks to replace the 20-year-old collegium system of appointing judges. The grounds: the new law impinges on judicial independence. CNBC TV 18's Ashmit Kumar, who was in court tracking the arguments, brings you the highlights.
The power to appoint judges to higher courts will remain with the judiciary and not with the executive. That's the message from the Supreme Court. The court ruled that the 99th Constitutional Amendment and the NJAC Act 2014, which allows for a commission featuring the Chief Justice of India, 2 senior-most Supreme Court judges, the Law Minister, and 2 eminent persons to decide on future appointments, unconstitutional and void. In a 4:1 verdict, the court said, and I quote, "The National Judicial Appointment Commission impinges on the judicial independence. The NJAC Act confers arbitrary and unchartered powers on various authorities. The NJAC Act has sought to limit the powers of the Chief Justice of India, both individually and institutionally." Justice Kher, as a part of its order, has also provided for now the system to go back to the collegium system of appointment, where, of course, we have the Chief Justice and the 4 senior-most judges making the case for judicial appointments. A bruised government, which has gone into a huddle after this verdict, is putting up a brave face, but its confusion is evident.
While upholding very dearly the principle of independence of judiciary, I regret to say that parliamentary sovereignty has received a setback today.
20 states have also concurred with the views of the parliament. That amendment was supported by 20 states.
Meanwhile, there were dissenting voices within the bench itself. Justice Chelameshwar, the lone dissenting voice, said, and I quote, "There is no accountability in the collegium system. Such a state of affairs does not either enhance the credibility of the institution or good for the people of this country. Comprehensive reform of the system is overdue." End quote. Meanwhile, there continues to be heated debate on the subject.
Is the Supreme Court's final view that the system that prevails is not any less than the system that you wanted to bring about, Parliament wanted to bring about.
The government is definitely in a tight spot with this ruling, especially because its arguments that the question of validity of the NJAC Act and the 99th Constitutional Amendment be referred to a larger bench have been struck down. One option it has, experts say, is to undertake a fresh legislative exercise to reform the collegium. But with this verdict suggesting that the apex court does not want the executive to interfere in its business, that may be easier said than done. In New Delhi, Ashmit Kumar.